Law, in its broadest sense, may be described as a system of rules and principles established by the authority of the state for the purpose of regulating human conduct within society. The law is not merely an assemblage of commands, it is a reflection of the social, political, and moral values of a community at a given point of time. From the earliest civilizations of Mesopotamia and Misr to the present-day constitutional democracies, mankind has always recognized the necessity of certain binding norms to maintain order, to protect rights, and to resolve disputes. The essential characteristic of law is that it is enforceable through the machinery of the state, which distinguishes it from other forms of social norms such as morality or etiquette. The legal system of India is largely based upon the common law tradition inherited from British colonial rule, though it has since been modified, expanded, and indigenized to suit the needs of a sovereign democratic republic. At the apex of this system stands the Constitution of India, which came into force on the 26th of January, 1950, and which serves as the fundamental law of the land. The Constitution is not merely a legal document. It is a charter of the nation's political identity and aspirations. It lays down the framework of government, distributes powers among its various organs, and guarantees certain fundamental rights to individuals, while at the same time imposing fundamental duties. Any law inconsistent with or in derogation of the provisions of the Constitution is void to the extent of such inconsistency. One of the most significant contributions of the Constitution has been the establishment of judicial review. The power of courts, particularly the Supreme Court and the High Courts, to examine the validity of legislative and executive action ensures that no organ of the state transgresses its constitutional limits. Judicial review thus acts as a safeguard against arbitrariness and tyranny, and secures the supremacy of the Constitution. The doctrine of basic structure, evolved by the Supreme Court in the celebrated case of Kesavananda Bharathi v. State of Kerala, 1973, is another remarkable development. According to this doctrine, Parliament has wide powers to amend the Constitution, but it cannot alter its basic features, such as the supremacy of the Constitution, the rule of law, separation of powers, and judicial review itself. In the realm of substantive law, one may broadly classify legal rules into civil and criminal. Civil law deals with the rights and obligations of individuals inter se, and provides remedies such as compensation, injunction, or specific performance. Criminal law, on the other hand, is concerned with acts or omissions which are considered injurious to society as a whole, and prescribes punishments such as imprisonment or fine. The Indian Penal Code 1860, drafted by Lord Macaulay, remains the primary source of substantive criminal law in India, while the Code of Criminal Procedure 1973 lays down the procedure for investigation, trial, and punishment of offenses. Civil disputes are governed mainly by the Code of Civil Procedure 1908 and various substantive statutes such as the Indian Contract Act, the Transfer of Property Act, and the Hindu and Muslim personal laws. The concept of natural justice forms an indispensable part of Indian legal jurisprudence. Natural justice, though not codified, is a fundamental principle which ensures fairness in administrative and judicial decision making. The two cardinal rules of natural justice are odi alterum partem, no one should be condemned unheard, and nemo judex in causa sua, no one should be a judge in his own cause. These principles, though rooted in common sense and morality, have been given constitutional recognition under Articles 14 and 21, which guarantee equality before the law and protection of life and personal liberty. Another vital dimension of law is the protection of human rights. India, being a signatory to the Universal Declaration of Human Rights and various international covenants, has incorporated several provisions safeguarding human dignity and liberty. The judiciary has expanded the scope of fundamental rights through progressive interpretation. For instance, the right to life under Article 21 has been interpreted to include the right to live with dignity, the right to health, the right to education, and even the right to a clean environment. Public interest litigation, developed by the Supreme Court in the 1980s, has opened the doors of justice to disadvantaged groups who otherwise lack the means to approach the courts. In conclusion, law may be viewed as the bedrock of civilized society. It embodies the collective will of the people, expressed through constitutional and legislative processes, and enforced through judicial institutions. While no legal system is perfect, the continuous endeavor must be to ensure that law remains responsive to the needs of the time, faithful to the ideals of justice, liberty, equality, and fraternity, and above all, respectful of human dignity. Only then can the majesty of law command the obedience and reverence of the people.